Committee will come to order. I want to welcome our guests, and we'll get to our witness here in just a few minutes. Subcommittee's hearing today continues the committee's ongoing oversight of the IRS's and its targeting of conservative tax-exempt groups. On May 10, 2013, Lois Lerner apologized for the Internal Revenue Service targeting and responding to a planted question at an obscure tax law event. 4 days later, Attorney General Eric Holder called the targeting outrageous and unacceptable, vowed that the Justice Department would begin a criminal investigation. That was May of last year. Here we are now, 14 months later, and we've heard virtually nothing from the Administration about its criminal investigation. All we have heard gives members on both sides of the aisle cause for concern. We've learned that Barbara Bosserman, an attorney in the Civil Rights Division, is playing a leading role in the investigation. Ms. Bosserman is a substantial contributor to the President and the Democrat National Committee, and now it's her job to investigate the targeting of people who opposed the President's policies. The Attorney General then comes out and says Ms. Bosserman's not alone. She's working with the Public Integrity Section and, of course, the Federal Bureau of Investigation. Then we learned that the Public Integrity Section and the FBI actually met with Lois Lerner in 2010 to discuss how to bring prosecution against these groups, the very same groups that were targeted by the IRS. These are serious apparent conflicts of interest, but the Justice Department just wants us to look the other way. No big deal, they say. Then we have unnamed law enforcement sources who leaked to the Wall Street Journal that no criminal charges were going to be filed in the IRS targeting investigation. And then you have the President of the United States go on national television and say there's not a smidgen of corruption in the Internal Revenue Service. Well, if that's not prejudging the investigation, I don't know what is. The House has passed a resolution calling on the Attorney General to appoint a special prosecutor. 26 Democrats, and I stress that, 26 Democrats joined every single Republican in the House of Representatives in approving this measure. But the Administration still won't do anything. They still won't appoint the special prosecutor. My question is this: what more will it take for the Administration to appoint a special counsel? And then we find out just last month that the IRS lost 2 years of emails from Lois Lerner due to a hard drive crash. Mr. Cole's testimony says that the Justice Department is investigating, and that, of course, is good. Someone in the Administration recognizes that there's something rotten with missing emails, but more must be done. We have serious concerns about the Administration's investigation and serious questions for our witness today. We need to hold all wrongdoers accountable for the targeting of Americans for exercising their First Amendment rights to speak out in a political fashion, and that's why this hearing is so important. And with that, I would yield to Mr. Cummings.
Thank you very much, Mr. Chairman.
For an opening statement. Gentleman recognized.
Chairman Jordan, and I welcome to this hearing Deputy Attorney General Cole. For more than a year, Republicans have claimed that the White House directed the IRS to target conservative groups. But now that we have conducted our investigation, we know the truth. There's no evidence to suggest that the White House played any role in directing or developing the search terms identified by the Inspector General as, quote, inappropriate, end of quote, or any other aspect of how IRS employees processed these applications. We have now conducted, ladies and gentlemen, 42 interviews. These were witnesses that were called by the Republicans. And they make it very clear that an IRS screening agent in Cincinnati developed these inappropriate criteria on his own. We also know from his supervisor, who described himself as a conservative Republican, that's his quote, that he did this not for political reasons, but because he was trying to treat similar cases consistently. Not one of the witnesses we interviewed, including senior officials at the IRS, the Treasury Department, and the Justice Department, identified any White House role in this process. Our investigation also confirmed the findings of the Inspector General, who was appointed by Republicans, whose audit stated that the IRS employees reported that they were, quote, not influenced by any individual or organization outside the IRS, end of quote. The Inspector General has testified repeatedly before Congress that he has identified no evidence of any White House role or political motivation. So now the Republicans have a different argument, although they are still trying to somehow link this to the White House. Now they claim that the targeting of the conservative groups is a massive government-wide conspiracy involving the President, the IRS, the Securities and Exchange Commission, the Federal Election Commission, and numerous other agencies, all coordinated in response to the Supreme Court's decision in Citizens United. They claim that the Justice Department is a key player in the conspiracy. They accuse the Department of engaging in they accuse the Justice Department of the United States of America of engaging in criminal activity by obstructing the committee. They claim the Department is delaying or even closing down its own investigation for political reasons, and they claim that the appointment of a special counsel is needed. Mr. Chairman, our staff prepared a detailed 32-page memo that sets forth the top 10 most egregious accusations against the Department of Justice, as well as specific responses showing why each one is unsubstantiated. And I ask unanimous consent that this memo be entered into the official hearing record.
Without objection.
Let me address just one of these allegations. Last month, Chairman Issa and Chairman Jordan sent a letter to the Attorney General claiming that the Department conspired with the IRS to compile an illicit registry with more than 1 million pages of confidential taxpayer information in order to criminally prosecute conservative groups for their political speech. Here is what that letter said. Quote, the IRS transmitted 21 disks containing over 1.1 million pages of non-profit tax return information, including confidential taxpayer information protected by federal law, to the Federal Bureau of Investigation in October 2010, end of quote. Their letter then accused the Department of working with the IRS to, quote, assemble a massive database of nonprofit groups, end of quote, which they called, quote, an illicit and comprehensive registry. These accusations are complete nonsense. There's no illicit registry. There's no singling out of conservative groups. The vast majority of information was available to the general public, and this information was never used for any investigation or prosecution. In 2010, the IRS provided Form 990s not only from conservative groups, but from all groups, regardless of political affiliation. And it wasn't until earlier this year, more than 3 years later, that the Department discovered that a very limited amount of confidential taxpayer information was stored on those disks. This was an inadvertent error that affected only 33 of 12,000 forms on those disks, less than half of 1%. The bottom line, as I close, is that these disks were never even reviewed by the FBI or used as part of any investigation or prosecution. On May 29th, the Department wrote a letter to the committee stating as follows, quote, FBI advises that upon receipt of the disk, an analyst imported the index, which is set forth in one of the disks, into a spreadsheet, but did nothing further with the disk. And to the best of our knowledge, the information contained on the disk was never utilized for any investigative purpose, end of quote. That's from the FBI. Where is the so-called illicit registry? The fact is that it simply does not exist. This is not the basis of a White House scandal. This is the latest example of Republicans desperately searching for one and then using any excuse they can to manipulate the facts until they no longer have any resemblance to the truth. Our committee has now held 10 hearings on the issue, and the IRS has spent more than $18 million responding to congressional investigations. It is time to stop wasting millions of taxpayer dollars and start focusing on reforms to help our government work more effectively and efficiently for the American people. And with that, I yield back.
I thank the gentleman. I would just also ask for unanimous consent to enter into the record a couple of emails from 2010 from Mr. Pilger, lawyer in the Public Integrity Section of the Justice Department, emails to Lois Lerner, and I'll just quote, "Thanks, Lois. The FBI says raw format is best because they can put this into their systems." Again, the point that the ranking member was just talking about, 1.1 million pages, 21 disks of information. The FBI got it in the exact format they wanted, had this information for 4 years, and I'm aware of the testimony from the Justice Department that they did not use this information. But what I also know is they had it for 4 years, and it did contain 6103 confidential taxpayer information.
But gentlemen,
so
yield
with
for
unanimous consent, I'd ask that we enter this into the record as well.
Gentlemen, yield just
Be happy
15
to give
seconds.
the ranking member.
And I would ask that Mr. Cole, since we want to be effective and efficient and not be caught up in distraction and dysfunction, that when he answers his questions, that he be allowed to answer what you just stated, because I want to hear the answer to that too. All right?
I do too, because we're going to ask him about it. I hope he does answer and doesn't say it's an ongoing investigation. I hope he does answer our questions today. That's why we got him here.
Very well.
Thank you. Anyone else wish to make an opening statement? For Mr. Cartwright, Ms. Duckworth? Oh, gentlelady is recognized.
Thank you, Mr. Chairman. I'm reading the opening statement on behalf of Ranking Member Cartwright. And also thank you, Deputy General Cole, for testifying today. On May 14, 2013, Inspector General Russell George released a report stating that IRS employees had used inappropriate criteria to screen applicants for tax-exempt status. Republican and Democratic members, including myself, condemned the IRS mismanagement identified in the Inspector General's report. Despite legitimate concerns expressed by some members before this committee had even begun to investigate, Chairman Issa went on national television and declared the IRS was involved in the targeting of the President's political enemies. The Inspector General has repeatedly refuted this baseless allegation. He reported that senior leaders at the IRS said the criteria were not influenced by any individual or organization outside the IRS. Then, on May 17, 2013, the Inspector General was asked before a Ways and Means Committee, and he, quote, "Did you find any evidence of political motivation in the selection of tax exemption applicants?" He responded, quote, "We did not, sir." After interviewing 42 employees from the IRS, Treasury Department, and DOJ, and receiving more than 680,000 pages of documents, the committee has not found any evidence of White House involvement or political bias. Despite these facts, Republicans continue to invent partisan election season conspiracy theories. One of the latest allegations is that the Supreme Court's decision in the Citizens United prompted President Obama, Democratic members of Congress, and the IRS, DOJ, and other agencies to launch a government-wide effort targeting conservative groups. While I firmly believe that the Citizens United decision severely undermines our campaign finance laws, allowing special interest dollars to drown out the voices of average Americans, Republican attempts to characterize these concerns as evidence of political pressure for agencies to target conservative groups lack merit. These preposterous accusations have also been contradicted by the committee's own investigation. We already know that the inappropriate criteria started with IRS employees in Cincinnati. The Inspector General's report said, and I quote, that they developed and implemented inappropriate criteria. The IRS screening group manager in Cincinnati confirmed this fact in a committee interview. He explained that his employees first came up with inappropriate search terms, not for political reasons, but to promote consistency. And he proved his point by telling us that he is a conservative Republican. Former IRS Commissioner Doug Shulman, a 2008 President Bush appointee, was asked, did the Citizens United case in any way affect the IRS process for handling tax-exempt applications? And his answer, no, to the best of my knowledge, it did not. Likewise, the head of the Election Crimes Branch at DOJ said, and I quote, Citizens United is not a problem. It is the law, and so no, I am not aware of any effort or part of any effort to fix a problem from Citizens United. While Republicans continue to promote their unfounded allegations, they conveniently overlook the funneling of dark money into elections. 501c4 organizations are not barred from participating in political campaigns, but the regulations are clear. They state that political activity must be an insubstantial amount of the group's overall activity, less than 50%. These groups can already gain tax exemption as a Section 527 organization, but that would require them to disclose their donors rather than keeping the American people in the dark about where they're getting their money. As I've repeatedly said, anonymous money in politics disrupts the democratic process. That is why Ranking Member Cartwright introduced the OPEN Act, which would require corporations and unions to disclose their political spending to shareholders and members. This legislation will shine a light on the dark money funding political activities. I commend Chairman Leahy and Senator Udall of the Senate Judiciary Committee for advancing SJ Resolution 19, a joint resolution proposing an amendment to the Constitution restoring reasonable limits on financial contributions and expenditures in elections. Thank you, Mr. Chairman, and I yield back.
Thank the gentlelady. Members will have 7 days to submit opening statements. For the record, we now welcome our witness, the Honorable James M. Cole, as Deputy Attorney General of the United States. Mr. Cole, you know how this works. If you'd stand up and raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Pleased to have you with us, Mr. Cole. Again, you've done this a few times. You got 5 minutes, more or less, but around 5, and you get to go, and then you got to answer our questions. So fire away.
I'll take less than that, Mr. Chairman. And before I start, I want to thank the Chairman for accommodating the request I made to have a rescheduling of the date of this hearing. When it was first scheduled, I was already scheduled to be down at the southwest border, looking at the McAllen Station and dealing with the issues down there and meeting with the United States attorneys on the southwest border to try and deal with the issues we have there as well. So thank you for accommodating that.
You bet.
I'm here today to testify in response to the committee's oversight interest in allegations that the Internal Revenue Service targeted conservative groups seeking tax-exempt status. When the allegations of IRS targeting surfaced in May of 2013, the Attorney General immediately ordered a thorough investigation of them. That criminal investigation is being conducted by career attorneys and agents of the Department's Criminal and Civil Rights Division, the Federal Bureau of Investigation, and the Treasury Inspector General for Tax Administration, that's known as TIGTA. I have the utmost confidence in the career professionals in the Department and in TIGTA, and I know that they will follow the facts wherever they lead and apply the law to those facts. While I understand that you are interested in learning about the results of the investigation, in order to protect the integrity and independence of this investigation, we cannot disclose non-public information about the investigation while it remains pending. This is consistent with the long-standing Department policy across both Democratic and Republican administrations, which is intended to protect the effectiveness and independence of the criminal justice process as well as the privacy interests of third parties. I can, however, tell you that the investigation includes investigating the circumstances of the lost emails from Ms. Lerner's computer. In response to your requests, we have undertaken substantial efforts to cooperate with the committee in a manner that is also consistent with our law enforcement obligations. We have produced documents relating to the limited communications regarding 501c organization by Criminal Division attorneys with Lois Lerner, who is the head of the Exempt Organizations Division at the IRS. We have also taken the extraordinary step of making available as fact witnesses 2 career prosecutors from the Department's Public Integrity Section who explained these contacts with Ms. Lerner. In 2010, for the purpose of understanding what potential criminal violations related to campaign finance activity might evolve following the Supreme Court's decision in Citizens United versus the FEC, a Public Integrity Section attorney reached out to the IRS for a meeting and was directed to Ms. Lerner. In the course of that meeting, it became clear that it would be difficult to bring criminal prosecutions in this area, and in fact, no criminal investigations were referred to the Department of Justice by the IRS, and no investigations were opened by the Public Integrity Section as a result of the meeting. A separate contact between the Public Integrity Section and Ms. Lerner occurred in May of 2013, when the Department of Justice had been asked, both in a Senate hearing and in a subsequent letter from Senator Sheldon Whitehouse, whether the Department and the Treasury Department had an effective mechanism for communicating about potential false statements submitted to the IRS by organizations seeking tax-exempt status. An attorney in the Public Integrity section reached out to Ms. Lerner to discuss the issue. Ms. Lerner indicated that someone else from the IRS would follow up with the section, but that follow-up did not occur. In sum, these two instances show that attorneys in the Public Integrity section were merely fulfilling their responsibilities as law enforcement officials. They were educating themselves on the ramifications of changes in the area of campaigns finance laws and ensuring that the Department remained vigilant in its enforcement of those laws. As we have explained to the committee previously, in 2010, in conjunction with the meeting I previously described, the IRS provided the FBI with disks that we understood at the time to contain only public portions of filed returns of tax-exempt organizations. As we have indicated in letters to the committee, the FBI has advised us that upon their receipt of those disks, an FBI analyst reviewed only the index of the disks and did nothing further with them. To the best of our knowledge, they were never used for any investigative purpose. Pursuant to the committee's subpoena, we provided you with copies of the disks on June 2, 2014, when it remained our understanding that the disks contained only publicly available information. Shortly thereafter, the IRS notified the Department that the disks appeared to inadvertently include a small amount of information protected by Internal Revenue Code Section 6103, and we promptly notified the committee of this fact by letter on June 4, 2014. We promptly provided our copies of the disks to the IRS and suggested that the committee do the same. In order to provide you with our best information regarding the disks, including the fact that they were not used by the FBI for any investigative purpose, we have now written the committee several letters regarding the disks, and the Director of the FBI answered questions about them from Chairman Jordan in a House Judiciary Committee hearing on June 11th of this year. We recognize the committee's interest in this matter. We share that interest and are conducting a thorough and complete investigation and analysis of the allegations of targeting by the IRS. While I know you are frustrated by the fact that I cannot at this time disclose any specifics about the investigation, I do pledge to you that when our investigation is completed, we will provide Congress with detailed information about the facts we uncovered and the conclusions we reached in this matter. Thank you, Mr. Chairman. I will now be happy to answer the questions.
Thank you. Gentleman from Florida, Mr. DeSantis, Vice Chair is recognized.
Thank you, Mr. Chairman. Good morning, Mr. Cole. Mr. Cole, we learned in Congress on June 13, 2014, that 2 years' worth of Lois Lerner's emails were missing. The IRS would not produce those. When did the Justice Department learn of that fact?
I think we learned about it after that from the press accounts that were in the paper following the IRS's notification to the Congress.
Okay. So you actually read about it in the press, so nobody in the IRS ever went to the Justice Department to give you a heads up, knowing that you were conducting the investigation, that some evidence may have been destroyed?
Not before the 13th of June.
Okay. Now, let me ask you this. If you said in your testimony that you share the committee's interest and you're conducting a thorough and complete investigation and analysis of the allegations of targeting by the IRS, if that is the case, then I guess my question is, why wouldn't you have known that these emails were missing? Did you just simply not seek to obtain those in the course of the investigation, or did the IRS not provide documents that the Justice Department requested?
Well, again, it's difficult to get into the details of the investigation, but there's a number of different sources of emails in the IRS. There's lots of recipients and senders, and we were looking at many different forms and sources of those emails, and it didn't become apparent based on that there were any missing emails before that.
Now, let me ask you this. If somebody, you're investigating an entity, government agency, whatever, that agency has a duty, once they know they're under investigation, to preserve evidence, correct?
That's correct.
And they have a duty to produce the relevant documents that are requested in the course of that, correct?
That's correct.
And that would fall, I guess, ultimately the agency head is responsible for ensuring that the agency complies with the Justice Department, right?
I would imagine the agency head ultimately bears responsibility, but there's people further down who actually do the work.
Now, in the course of investigating a case, if you're investigating an agency, an entity, and there's evidence that is destroyed, and that agency knows that they're under investigation, don't they have a duty to report that to the Justice Department so that you know that the evidence has gone missing?
We would like to know that information. It depends on when they learn of it, and it's certainly information that we would like to have.
Let me ask you this. If you're in court and you make a representation to a judge, even if it's in good faith, and you later find out that the representation you made is factually incorrect, you have a duty as an attorney and a member of the bar to go back to the court and follow a duty of candor to inform the tribunal of the mistake and correct the record. Is that right?
That's correct.
So do you think that as you in the Justice Department look in a congressional investigation, if we have somebody heading an agency or who's involved with an agency and they provide information to us and that information later they determine to be incorrect, do they have a duty of candor to the Congress to correct the record?
Yes.
Very well. Let me ask you this, Mr. Cole. There was a letter. We had sent a subpoena for documents, and we received a response on May 28, 2014. It was signed by Peter Kadzig. And in that, the Department's position is the same. There are certain items that we requested that the Department's not going to produce. Is that accurate?
That's correct.
Okay. And the reason for that cited was substantial confidentiality interests. And I just wanted to clarify, is not producing the documents, is the reason for that, is the President actually exerting executive privilege in this matter?
I don't believe there was an assertion of executive privilege. There's law enforcement sensitive documents and documents involving ongoing investigations that traditionally over decades, the accommodation with the Department and the Congress is that those are not produced because they are law enforcement sensitive items.
My final question would be, this Congress held Lois Lerner in contempt, almost 9 weeks ago. Federal law requires when that happens that the U.S. Attorney for the District of Columbia take that to a grand jury. Is it your understanding of that law that that is an obligatory duty, that the U.S. Attorney must take that before a grand jury?
My understanding of the law is that it does not strip the U.S. Attorney of the normal discretion that the U.S. Attorney has. He proceeds with the case as he believes it is appropriate to do so.
So 2 U.S.C. 194 says it shall be the duty to bring the matter before the grand jury. So you're saying that actually, even though Congress mandated a duty, a prosecutor would essentially be able to trump that language by exercising discretion?
I believe that there's aspects of it that give any prosecutor prosecutorial discretion on how to run a case and how to review a matter. I understand this matter is under review, and as far as whether or not it has been presented to the grand jury, that's information that you can't disclose because grand jury proceedings.
I understand that entirely. Okay, my time is up. Maybe we'll follow up on that, and I yield back.
The gentleman from Maryland is recognized.
Deputy Attorney General Cole, I want to thank you very much for being here, and I wish it were under more constructive circumstances. Unfortunately, the Republicans on this committee has accused your department, the Justice Department, of engaging in criminal conduct, of obstructing the committee, and of conspiring with the IRS to criminally prosecute conservative groups for their political speech. So let me ask you directly, are any of those accusations true?
No, they're not.
Okay, let me focus on one specific accusation. Chairman Issa and Chairman Jordan have accused the Department of Justice of conspiring with the IRS to create what they call an, quote, illicit registry, end of quote, of confidential taxpayer information to prosecute conservative organizations. The claim is based on the fact that back in 2010, the IRS provided to the FBI 21 computer disks with annual tax returns, or Form 990s, from organizations with tax-exempt status. According to your letter, these disks contain the forms of all groups that were filed between January 1, 2007 and October 1st, 2010, and I quote, regardless of political affiliation. Is that correct?
That's my understanding, Representative Cummings, but I have not seen the list myself. My understanding is it was presented to us as public record information and not selected on the basis of any sort of political affiliation.
So based upon your knowledge, they were not just conservative organizations?
No, that's not my understanding.
As I understand it, the vast majority of this information is accessible to the public. This public information is the same as what the IRS provides to the nonprofit organizations guidestart.org. Is that right, to your knowledge?
My understanding when we received the disks is that it was represented to us that it was all public information.
So these forms were provided in 2010, but earlier this year, more than 3 years later, you discovered that a very limited amount of confidential taxpayer information was stored on those disks. Is that correct?
That's correct.
This error affected only 33 of 12,000 forms on those disks. That's less than 1%. Is that your understanding?
I don't know how much specifically it was. I knew it was a small amount.
Do you have any reason to believe that this error was intentional or that these redactions were done incorrectly or on purpose?
I have no basis to be able to conclude anything on that other than it's just a small amount and what was represented to us when we received them.
Okay, well, finally, to me, the most important point here is that these disks were never reviewed. Is that right, to your knowledge?
That's correct. Other than the index, the basically first page of it, they were never reviewed and never used.
And so, Deputy Attorney General Cole, to conclude, when you hear claims, and I hear, having dealt with the Justice, having practiced law for so many years, and dealt with the Justice Department in so many times, and I mean some of the our best and brightest citizens go into that department. Many of them could make a lot more money doing other things, but they decide that they're going to give their life to what I call feed their souls and make a difference for people. And then to just the idea to hear that the Justice Department is accused of criminal activity, the very department that has done so much to make sure that our laws are upheld. I mean, it's very upsetting to me. And I'd just like to give you an opportunity, since you represent so many of these wonderful people who have decided to give their careers to us, and the idea that they're working hard, but then they hear these accusations. But I just want to know your reaction to that.
Well, Ranking Member Cummings, I represent all of them. And the career people we have at the Department of Justice are really some of the best and most honest lawyers I've ever seen. The amount of integrity that's there is really quite astounding. You're right. They do sacrifice a great deal of money to work there, but they work there because they feel that it's important to go after the pursuit of justice. They work to try and find out what the facts are, what the law is, apply the facts to the law, and let the chips fall where they may. There is no politics that's involved with all of these career people, and it's really impressive to see the work that they do and the results that the Justice Department is able to bring about and the credibility that the Justice Department has because of the wonderful work of the career lawyers that we have.
It is my understanding that if you all find that this crash of Ms. Lerner's computer had any criminal elements in it, you would be looking into that and addressing it as you would any other criminal case. Is that correct?
That's what we do in everything. We look to determine whether there is any facts of any criminal violations of any Federal laws, and if there are, we act appropriately. That's the whole purpose of the Justice Department, is to find out what's going on, what the truth is, and then take appropriate action.
Thank you very much, Mr. Chairman.
I thank the gentleman. Mr. Cole, isn't it true that Richard Pilger met with Lois Lerner back in 2010?
Yes, it is.
All right, and isn't it true that he got the information, this 1.1 million pages of information in the format that he asked for it? The FBI wanted it in?
I think there was a request of several different forms it could come in, as I understand it, and we were asked to pick which one the FBI would prefer.
Lois Lerner said, we're checking with my folks on getting you the disk we spoke about. Incoming data regarding 501c4 issues. Does the FBI have a format preference? Mr. Pilger says the FBI says raw format is best because they can put it into their systems like Excel. So you got it. So Pilger meets with Lois Lerner. You guys asked for specific information. That's right? You guys asked for this data?
I'm not sure. I haven't seen an email specifically asking for it. I think all of that
Well, it
preceded.
sure implies when you get it in the format you want, when you say, well, we'd like it in the Excel format, we'd like regarding 501c4. So it sure looks like you asked for it, and then you got the data, right?
My understanding is we did get the data, that the requests were made before the meeting,
Well, here's
and
a
that the
question.
data was delivered
Here's a question.
after
If
the
it's
meeting.
publicly available information, why did you ask the IRS for it, and why did you have to meet with Lois Lerner to get it?
I don't have an answer to that right now, other than maybe
Well, that's an important point. We'd like an answer to that.
I can take that back and try and find it.
No, you're the one who said several times already it's public information, yet you had to go to Lois Lerner in the IRS and get it in the format you wanted? And Mr. Cummings says that's no big deal? And you had it for 4 years? You had this for 4 years, correct?
The information, the disks were in the possession of the FBI for
21 disk,
21 disks.
1.1 million pages,
I think that's correct.
and most importantly, it did contain 6103 information, correct?
We learned that on about the second.
I didn't ask when you learned it. I said it contained it, correct?
We learned it late that it contained it, yes.
Mr. Cummings just made this big deal out about this is no big deal. Well, in fact, it is. The Justice Department asked for information that you said is publicly available, but you go to Lois Lerner to get it. You get it in 2010 in the format you want it. It's 21 disks, 1.1 million pages. You say it's available publicly, but you don't get it publicly. You go get it from the IRS, and it contains confidential taxpayer donor information. All those are facts, correct?
They're not necessarily facts that are all linked together, though, Mr. Chairman.
They're all in the
Facts that
database.
exist.
They're all in the database, correct? The IRS told us it was confidential. I didn't make that up. Chairman Issa didn't make that up. The IRS told us it was confidential information in there.
There was no request at the time. I'm not even sure if the
Now, let's go to-
Justice Department requested the information or if the IRS offered it. I'm not sure how the idea of
When you
providing
get it in
to
the format
Justice-
you asked for,
If I
it
can
sure looks
finish-
like you asked for it.
If I can finish, Mr. Chairman, I'm
Okay.
not sure how the actual idea of providing that information to the Justice Department came up
let's go to
4
your-
years ago, but it was provided after the meeting.
Let's go to your testimony, your written testimony. You say on page 2 of the written testimony I got that there was a separate contact between this same lawyer, Mr. Pilger, and Ms. Lerner in 2013 in response to Senator Whitehouse comments in a Senate hearing looking at ways to bring a false statement action against the very groups who wound up being targeted by the IRS, right? You follow where I'm at in your testimony?
No, it has nothing to do with the groups targeted by the IRS. That's not correct.
Regarding false,
Whether or not false statement cases could be brought.
they're the same groups, trust me. And an attorney in the public integrity section reached out to Ms. Lerner to discuss the issue, correct? I'm just reading your
correct.
testimony. Ms. Lerner indicated that someone else from the IRS would follow up with the section, but that follow-up did not occur. Why didn't the follow-up occur?
I don't know.
You don't know?
I don't know. That would be.
Let me give you a reason why I think it might not have occurred. Because this correspondence, this meeting took place on May 8th, 2013. You know what happened 2 days later, Mr. Cole?
Yes, I do.
What happened 2 days later?
Ms. Lerner gave a speech at an ABA conference and talked about this issue.
Yeah, where she explained to the whole world that the IRS was caught with their hand in the cookie jar, and they, in fact, were targeting conservative groups. That's why the follow-up didn't occur. So 2 days before, the very lawyer who met with Lois Lerner in 2010 got the database in the format they wanted. 2 days before jump ahead 3 years later, 2 days before Ms. Lerner goes public, he's meeting with Ms. Lerner again and saying follow-up will take place, but the follow-up doesn't take place because Ms. Lerner goes public and says, you know what? Targeting did, in fact, happen. She tried, with a planted question at a Bar Association speech, spin this in a way that blames good public servants in Cincinnati, which we know is false. And Mr. Cummings said that's no big deal, that you had all this information. Give me a break. One last question I have before I go to the next member. So John Koskinen told this committee just a week ago that he knew in April of this year that a substantial portion of lowest learners' emails were lost. And he waited 2 months to tell us, and he waited even longer to tell you. If a private citizen does something like that, under investigation, finds out they've lost important documents, and doesn't tell someone, that's a problem. So is it a big deal to you, Mr. Cole, and a big deal to the Justice Department that the head of the Internal Revenue Service waited 2 months to tell the United States Congress, 2 months to tell the American people, and most importantly, 2 months to tell the FBI and the Justice Department that they had lost lowest learners' emails?
This is a matter, obviously, we'd like to know about the loss of the email.
I'm asking, is it a big deal that he waited 2 months?
It depends on what the circumstances were behind it.
Circumstances were, he knew in April. He said that when I asked him questions just last week, he said he knew in April. And I asked him, why didn't you tell us? And he would, but he waited 2 months.
I would like to know all the circumstances from him as to why there was the 2-month wait.
I would have liked to know right away as well.
Before I answer the question whether it's a big deal.
All right. Yield to the gentlelady from Illinois.
Thank you, Mr. Chairman. I believe that in his testimony, he actually, the response to why there was a 2-month wait was that he was informed, and then for the next 2 months they were attempting to recover the lost emails from other host computers where those emails were located, so that just because you lose the emails from Ms. Lerner's hard drive, where she was the from sender, that they would exist in the 2 recipients' computers. There were, I believe, over 80 other host computers where they were looking. So that is part of the delay. But I would like to know also the full extent of what was going on as well. Deputy General Cole, as I'm sure you're aware, the nature of the Justice Department's investigation into the IRS practices regarding the tax-exempt applications has been subject to lengthy discussions before various congressional committees. Despite unsubstantiated allegations that the Justice Department has prematurely closed its investigations for political reasons, Attorney General Holder has repeatedly confirmed before both the House and Senate Judiciary Committees that the Justice Department and FBI are still actively investigating this matter. On January 29, 2014, the Attorney General testified before the Senate Judiciary Committee that the matter, and I quote, is presently being investigated, interviews are being done, and analysis is being conducted. Several months later, on April 8th of 2014, the Attorney General further testified before the House Judiciary Committee and confirmed that the Department's investigation was still an ongoing matter that the Justice Department is actively pursuing. Deputy Attorney General Cole, can you please confirm that the Department is still actively investigating IRS practices surrounding tax-exempt applications?
This is still an ongoing investigation. That's correct.
Thank you. So accusations that the Department has prematurely closed its investigations are false. Is that correct?
That's correct.
Thank you. Some have also lamented the length of time this investigation has spanned. In your experience, is it uncommon for complex investigations such as this one to take a substantial amount of time to complete?
Both as a prosecutor and a defense attorney, this is not an unusual amount of time for an investigation like this.
Thank you. In your opinion, is there anything unusual or troublesome about the length of time the Department's IRS investigation is taking?
Not that I've seen, no.
So this is standard. This is other investigations of this complexity you would expect would take a similarly lengthy amount of time?
This is normal, yes.
Okay. Can you comment on reports that the Justice Department has decided not to bring charges against IRS officials?
No decisions have been made in this case.
Okay. Can you confirm that no decision has been made yet about whether to criminally charge anyone in DOJ's ongoing investigation? I know you said that, but because in reference to the fact that the investigation is still ongoing.
There have been no decisions made about this case as of right now.
So there's still potential for criminal charges if you were to discover in the investigation some cause?
The whole range of options are still open.
Thank you. I thank you for your cooperation today, and I want to give you a chance to respond to some of the allegations, whether the Justice Department worked with the IRS to compile the massive database for illicit and comprehensive registry by federal law enforcement officials. Was this something that was a collusion between the Justice Department and the IRS?
No, it was not.
Did the DOJ or the IRS use this registry for the potential prosecution of nonprofits?
We didn't. As a matter of fact, we didn't use it for any purpose.
Okay. And both Chairman Issa and Chairman Jordan have said that in the letter on June 10, 2014, that a special prosecutor is needed for truly independent criminal investigation of the IRS targeting. Do you support that?
I do not. I don't think one is necessary here.
Okay. Now, I'm going to give you a little time to respond to the accusations on how the DOJ is conducting this investigation and these allegations that you're colluding, that you're delaying, that you're lying. And I only have 30 seconds left, so it's not a lot of time, but go ahead.
Well, short of saying we're not doing that, this is the same thing. We're not talking about what we're doing in investigations either way. If my answers would help us or would hurt us, we're not talking about what we do in investigations. That's just how we proceed with investigations for a lot of very good reasons.
Why would that? Can you name some of the good reasons why you would do that in general?
You don't want, first of all, you don't want people to prejudge when not all the facts are in. You want to make sure that you gather all the facts that are available so that you have a complete and full record upon which to make the determinations. You want to protect people's privacy, because many times people will provide us information, and you don't want to start going out and telling everybody who is talking to us, who is not talking to us. You don't want to have some witnesses infected by what other witnesses have said, so that you can get the pure statements from each type of witness. Some people you may just want to make sure they're protected because there are allegations about them that turn out not to be true, and it's not fair for those to be published. You also just want to make sure that everything is done with fairness and thoroughness, and you want to make sure that you have the ability to do that without the interference and the glare of a public spotlight. That's not the way investigations are done well.
Thank you. I'm out of time, Mr. Chairman.
Mr. Cole, would that include the President of the United States prejudging the outcome of the case when he said there's not a smidgen of corruption? You just talked about how you didn't want anyone saying anything, you can't know who you're talking to, what's going on, but yet the head of the executive branch prejudges the entire investigation on a nationally televised interview?
Mr. Chairman, I'm talking about what the Department of Justice does. Lots of people—
You're talking about doing a good investigation, getting to the truth, and you don't want certain witnesses and certain people talking about it. I would think that would include the highest-ranking official in the country.
Mr. Chairman, if I may, we don't want— the Justice Department doesn't talk about the investigation. We're the ones who know what the facts are and what the facts are that we're gathering. Lots of people have talked about this investigation on both sides of it. They're free to do that. That's part of the First Amendment rights. We do not do that because we're the ones with the actual facts.
Well, but the President's different. Your boss is Eric Holder. His boss is the President of the United States. That's a completely different category than members of Congress or a private citizen talking about it. All I'm saying is you just went through a whole list of why you can't talk about certain things. You can't tell us what you're doing. You can't even tell us who's all involved in the case. But somehow we bring up the President. No big deal. I just failed to get that one. The gentleman from Arizona, Mr. Gozar, is recognized.
Given the topic of this hearing, I assume you're familiar with the portion of the Code of Federal Regulations dealing with the prohibitions on disqualification arising from personal or political relationship with regard to a criminal investigation, correct?
Yes.
That's Title 28, Section 45.2 of the Code of Regulations, correct?
That's correct.
So you surely understand that it explicitly states, and I quote, "No employee shall participate in a criminal investigation or prosecution if he has a personal or political relationship with any person or organization substantially involved in the conduct that is the subject of the investigation or prosecution, or any person or organization which he knows has a specific and substantial interest that could be directly affected by the outcome of the investigation or prosecution." Do you understand that?
Yes, that's what it says.
You probably also understand that there is a carve-out section, B, that states, "An employee assigned to or otherwise participating in a criminal investigation or prosecution who believes that his participation may be prohibited by paragraph A of this section shall report the matter and all attendant facts and circumstances to his supervisor at the level of the section chief or the equivalent or higher. If the supervisor determines that a person or political relationship exists, he shall relieve that employee from participation unless he determines further in writing, after full consideration of all the facts and circumstances, that the relationship will not have the effect of rendering the employee's services less than fully impartial, professional, and The employee's participation would not create an appearance of a conflict of interest likely to affect the public perception of integrity of the investigation or prosecution. You understand all of this applies to the Department of Justice, correct?
Yes, it does.
Do you dispute that this is the regulation and guidance under the Code of the Federal Regulations?
This is the regulation and the guidance. Yes, sir.
Do you believe that Barbara Bosserman, attorney of the Department of Civil Rights Division and a major contributor to the President Obama's campaign and the Democratic National Committee, meets those standards set forth in the Code?
You have to look at Section C of that regulation, which defines those terms. And it defines a political relationship means a close identification with an elected official, a candidate, whether or not successful, for elective public office or a political party or a campaign organization arising from service as a principal advisor thereto or a principal official thereof.
But wouldn't you say a principal advisor is somebody that contributes to that party?
No.
Or the candidate?
An advisor would not be a person who makes a contribution.
Really? Do you also believe that she should also have brought this forward as a conflict of interest?
I believe that as the definition states, she didn't fall within the political relationship under the definition.
Well, let me ask you a question. Are you familiar with the impeachment of Richard Nixon?
I am.
Article 2, Exhibit 1 was the IRS. So this is very, very poignant in the public's mindset is the power to tax is the power to destroy. So, I mean, even more scrutiny should be applied to this. Would you not agree?
We're applying a great deal of scrutiny to this.
So, I mean, once again, the same type of code should be very explicit to Ms. Bosserman in regards to making sure that it's squeaky, squeaky clean in regards to the perception to the public.
I agree, and she did not meet the definition.
Sidestepping, I would say. I mean,
I would respectfully disagree.
I'm not an attorney, but I'm a dentist, and just the implication of that aspect in a public light, Main Street America, would show that there was a conflict of interest. And I think from that standpoint, the public is the one that we should be adhering to, their perception of making sure it's a fair and equitable evaluation. And I think that goes not only to you, but also Mrs. Bosserman in regards to their concept to the public. And I think they owe that further detail. Would you not agree?
Well, I think you have to go through the regulations. You have to apply the law to the matter. And the law in this matter has a very clear definition of what is meant by the terms. And those terms did not encompass Ms. Bosserman.
I see. So I want to go back to some of the comments you made here. I mean, the President made a comment that there's not a smidgen of opportunity there's corruption in this case. Would you agree with that terminology?
Congressman, this investigation is opened. And
well, I mean, I'm going to cut you off there because how would you define a smidgen? Small?
Congressman, I am
Smidgen,
not,
small. Is it big? Is it small? What's a smidgen?
I'm not sure the context and the meaning that the President gave.
So you weren't watching the Super Bowl?
I was.
So you actually did hear that. So, I mean, you're a literate person, so a smidgen would be what?
A smidgen is small.
So in this case, there is not an opportunity for something to be wrong and corruptive in this aspect, from your professional judgment?
Congressman, I'm not going to comment on the findings that we have made so far and the facts that we've gathered in this investigation. We don't do that. If somebody else wants to render an opinion.
Let me ask you a question. I'm going to cut you off right there. You made a comment to the ranking member that these individuals that work as career attorneys are fantastic people. Are they human?
Of course they are.
So they do make mistakes?
Of course they do.
Well, thank you very much.
Gentleman from Pennsylvania is recognized.
Thank you, Mr. Chairman. Deputy Attorney General Cole, thank you for being here today. I do hope we can use this opportunity to lay to rest some of the more outrageous allegations that have been circulating about the Department of Justice. As Chairman Issa and Chairman Jordan's May 22, 2014 letter to Attorney General Holder noted, they were, quote, shocked to learn that the Justice Department and the IRS had a meeting attended by Lois Lerner in early October 2010 to discuss the criminal enforcement of campaign finance laws. In that letter, Chairman Issa and Chairman Jordan claimed that testimony about the October 2010 meeting quote, reveals that the Justice Department contributed to the political pressure on the IRS to, quote, fix the problem, unquote, posed by the Citizens United decision, unquote. Question. Deputy Attorney General Cole, do you have any reason to believe that the October 2010 meeting between IRS and DOJ representatives was improper in some fashion?
No, I do not.
Okay. And I also wanted to say, during the transcribed interviews of the DOJ witnesses, committee staff asked about that October 2010 meeting. The chief of DOJ's Public Integrity Section had the following exchange with committee staff. Question. At the October 8, 2010 meeting, did you or anyone else from the Department of Justice suggest to IRS employees that they should, quote, fix the problem posed by Citizens United decision, unquote? Answer, no. And the question was, in your opinion, does the Citizens United decision pose a problem? And the answer was, it is not my role to comment on the law of the land. It is the law of the land. My job is to enforce the law. Citizens United is the law of the land. That was the answer that was given. And Deputy Attorney General Cole, do you agree that Citizens United is the law of the land and that it is DOJ's role and responsibility to enforce that law?
Yes, it is, and to enforce all the other laws that are involved in that area.
All right. Now, the Director of the Election Crimes Branch of the DOJ's Public Integrity Section was asked about Citizens United during his interview. In response, he said the following, quote, so Citizens United is not a problem, it is the law. And so, no, I am not aware of any effort or part of any effort to fix a problem from Citizens United. I am aware that it changed the law, though, and that law enforcement in reaction to such changes must be vigilant about the opportunities they present for law-breaking. So my question for you, Deputy Attorney General Cole, are you aware of any attempt by the Justice Department to, quote, fix a problem posed by Citizens United?
I'm aware of no such effort. There was no problem, particularly. That was the law.
Well, now that statements from DOJ witnesses and Deputy Attorney General himself have directly refuted the Chairman's allegation that DOJ, quote, contributed to the political pressure on the IRS to fix the problem posed by the Citizens United decision, I want to say I hope this claim is put to rest once and for all. It's time to stop creating fake scandals and start focusing on conducting real oversight, which is the charge of this committee. And I yield back.
I would just ask to unanimous consent to enter into the record a statement made by Ms. Lerner at a speech 8 days after the meeting that Mr. Cartwright just referenced. This is a speech at Duke University, October 19, 2010, where Ms. Lerner said, and I quote, everybody's screaming at us right now, fix it now before the election. We got what Mr. Cartwright said, but what we do know is that Ms. Lerner gave a speech 8 days after that meeting and said, everybody's asking me to fix it.
Mr. Chairman.
I would yield to
Mr. Chairman, a unanimous consent request?
unanimous consent request.
I thank the Chair. Since we're putting stuff on the record, I would ask unanimous consent that the full transcript of the staff interview with the Director of the Election Crimes Branch at DOJ.
I object. It is not the policy, Mr. Chairman, it is not the policy of this committee to put transcripts in the entirety out. I respect the gentleman's right to take any and all pertinent areas, but putting the questions and answers of transcripts has proven to be used to coach witnesses. And the coaching of witnesses later on, I'm sure Mr. Cole would tell you, is not productive in an investigation.
Yes,
The gentleman from California.
I would just, Mr. Chairman, I have a second unanimous consent request. I would further ask, since, we don't want to cherry pick around here, I was simply trying to avoid that, because I know that the committee chair frowns on that, that the May 29, 2014 interview with the Chief of DOJ's Public Integrity Section also be entered into the record.
Again, I object unless the gentleman can cite appropriate items. He's certainly welcome to. But the policy of this Chair is that it is destructive to ongoing investigations to do entire transcripts, and for the most part it has been avoided.
Well, Mr. Chairman, at the invitation of the Chairman, then I will cite two sections of those interview I hope the Chairman would not object to, be entered in the record at this time.
I think that's fine.
But I'm afraid I'm going to have to read them because otherwise you won't know. All right.
Exactly.
So the Director of Election Crimes Branch on May 6, 2014 said, and I quote, "Since I joined the Public Integrity Section in 1992, I've never encountered politically motivated decisions. To the contrary, it's been my consistent experience this section is acted without exception on a strictly nonpartisan basis in all of its decisions and actions. In my experience, politics plays no role in our work as prosecutors, period." That was part of his interview, and I'd ask without objection that be entered into the record. And then the second one, Mr. Chairman, and then I'll cease. On May 29th, John Kennedy's birthday of this year, he told the Chief of DOJ's Public Integrity Section explained to our staff, and I quote, "Since I've been Chief of this section, of the Public Integrity Section, I have never encountered, nor would I tolerate, any politically motivated decisions. Politics does not and cannot play a role in our work as prosecutors." And I thank the Chair.
All right. Thank you, gentlemen. We're going to try to get to two more before we got a couple votes on the floor. So the Chairman of the committee is recognized.
Thank you, Mr. Chairman. General Cole, a couple of areas. Would you agree that it would be wrong to continue an investigation for any length of time if there isn't a smidgen of evidence of wrongdoing?
If you've completed the investigation and you have satisfied yourself that there is no wrongdoing in the investigation, then the investigation is done.
That wasn't my question, General Cole. My question was, if you begin an investigation and you go through weeks, months, now basically a year, and you do not have a smidgen of evidence of a crime, is it appropriate to continue spending taxpayer dollars?
It depends on whether you think there is a chance that you may find additional evidence of crime.
So,
whether
Mr.
you've
Cole,
taken off the avenues
Mr. Cole,
that you need to.
General Cole, you have an ongoing investigation. It has been going on now for a year.
That's
you
correct.
have confirmed an ongoing investigation. So it is appropriate to say that your answer is that there either has to be evidence of a crime or a belief by your investigators that there is, in fact, a crime that has been committed that you are investigating. Isn't that correct?
There has to be a belief that there is still evidence that is necessary to be looked at to determine whether or not a criminal statute has been violated.
Mr. Cole,
That's the purpose
Mr. Cole,
of the
I really appreciate your dodging on behalf of decorum, but
Not dodging.
my question needs to be answered.
The purpose
You
of
cannot spend taxpayer dollars if you do not have a belief that it's going to lead to a crime. That would be a frivolous investigation at some point, wouldn't it? You continue looking for crimes for years on innocent people when, in fact, there isn't a smidgen of evidence. You continue looking at somebody for criminal investigation for months or years without any evidence just because you, in the long run, think it might happen?
You start investigations based on an
No, that was a yes or no, General Cole. It really is. Do you do that? I outlined a rather repugnant accusation that the minority has made about this Chair and this committee, that we're continuing to investigate wrongdoing by the IRS, both in Cincinnati and particularly in Washington, led by Lois Lerner. We continue to investigate it because we believe, and Ways and Means has referred to you, criminal allegations. Do you continue to investigate? If not, we're not talking about whether or not you're going to get a successful prosecution, a conviction. We understand that all of that, sometimes you go for years and you never get, like organized crime, you don't necessarily get a conviction. You don't get what you need. But would you continue investigating as you have if you did not have, if your investigators did not have a belief that a wrongdoing had occurred for which you were trying to build a case? And please, that's a yes or no.
Mr. Chairman, unfortunately, it's not quite a yes or no.
Oh, yes, it is, and we're going to have this conversation. Would you continue to take people's time, money, force them to get attorneys, investigate, subpoena, grab information, interview people. Would you do that if you did not have a belief that there was a possibility of a crime and one that you thought worth investigating? Would you do that?
Can I give you my answer, and then you can always follow up? And
You could give me a yes or no, and then you could further explain. That's how, your boss, the Attorney General, is a bad witness. Please don't be a bad witness.
I'm trying not to be a bad witness.
Okay.
But not
that
every
was a
question is
question.
a yes or a no.
Mr. Cole, that was a question that you could answer yes or no. Would you continue to investigate people without a smidgen of evidence? Would you continue to spend the taxpayer dollars when, in fact, there was no reasonable belief that a crime had been committed?
Sometimes you investigate to ensure that you have evidence that one wasn't committed.
So
or
you
to
could
find out
be,
whether
you
one
could
was
be,
committed.
Mr. Cole, that means that you could be spending the time and money trying to prove that Lois Lerner is innocent and that this committee was wrong in accusing her. You could be doing that.
We're not trying to prove anything.
I didn't ask what you were trying to do. I asked
We're trying to find out what the facts are and determine whether
okay, well,
or not there is action
let me
that
get
should be
to
taken.
my obligation to try to get to the facts. I issued you a lawful, constitutionally mandated subpoena. I issued a subpoena to the Attorney General, and in it we asked for all documents and communications between Lois Lerner and employees of the Department of Justice. You responded and said, we also have not included documents reflecting the Department's internal deliberations about law enforcement matters, fine, in which we have substantial confidential interests because we believe that the disclosures would chill candid exchange of interviews that are important to sound decision-making. You recognize those words? Mr. Peter Kazak, sitting behind you, could shake his head, yes, he signed the letter.
That's a standard policy of the Justice
Okay,
Department.
so I just want to make it clear. The standard policy of the Department of Justice is you don't give us the Q&A of your interviews because it could have a chilling effect on or adversely affect your ongoing investigations. Is that correct?
That's correct.
Great. I just wanted to make sure we understood that was what good investigations do. However, when we subpoenaed the documents between the Department of Justice and Lois Lerner, we got one tranche. That tranche shows that, in fact, either Justice wanted the goods on lots of people, including information that wasn't publicly available, taxpayer ID information, or Lois Lerner sent that information and the Department of Justice didn't want it. It's only one of the two because it did get sent. When we subpoenaed all the communications, was there any reason that you would not and have not delivered to us all of those documents, since that is not your investigation of Lois Lerner, but in fact our investigation of you?
I would have to.
You being the Department of Justice in addition to Lois Lerner, since there obviously was a relationship there in which documents inappropriate to be sent were sent.
Right. I'd have to go back and look. There's a difference between the documents that were created at the time and documents that have been created in determining how to respond, as is described in the letter. I don't know which documents are being withheld at this point, Mr. Chairman, so we'd have to look at those to see which ones they are.
Will you commit today, in the case of documents that would have been exchanges between Lois Lerner or documents that Lois Lerner may have asked to be sent back and forth, communications in those periods of time? This is before, obviously, before you were debating whether to give us information or not, but the documents related to her activities and the IRS's activities. Will you agree either to give us all the documents related to correspondence back and forth between the IRS and anyone at the Department of Justice in this time period that may have been related to the ongoing investigation, 501c3s and C4s and so on, or give us a privilege log, understanding that as an attorney, one or the other is due us? Will you commit to do that?
We will commit to give you the documents, or we will give you an indication of what types of documents we are not providing you, as we have done in the past, so that you will understand.
Will you do it in the form of a privilege log so that the documents have sufficient specificity to individually make the claim of why there is a specific privilege, not a blanket, we're giving you some, we're not giving you others, if you don't mind?
My understanding, Mr. Chairman, is that we have not given privilege logs in the past, and we see no reason to start that now, but we will give you information that will allow you to understand the nature of the documents that are not being provided.
My understanding is that your boss has been held in contempt because he refused to give us documents related to laws being broken by lying to Congress and the people who knew about it for 10 months, and those internal documents have yet to be produced, in spite of the fact that it's before the Court and 2 years later. So understand, I don't care about your history. I don't care about anything except the Constitution. And when the discussion was going on about Citizens United, I almost interrupted for one reason. It's not about the law. Citizens United is a constitutional decision. It is not a law that can be fixed. You cannot fix a constitutional decision. The Constitution was a decision that the President objected to. The Constitution was the one that he truly failed to have decorum in the well of the U.S. House of Representatives when he reprimanded the Supreme Court for their decision in Citizens United. And Lois Lerner thought publicly and said publicly, they want us to fix it, and Lois Lerner went about trying to fix it by going after conservative groups for what they believed and working with the Department of Justice to try to get audits and further prosecution of people who essentially were conservatives and asserting their constitutional free speech. So, Mr. Cole, I hope that you would never investigate Lois Lerner or the crimes related to this if there wasn't a smidgen of evidence. I would hope that you were doing it because, in fact, as we know on this committee, crimes were committed, regulations were violated, rules were broken, and Americans' constitutional rights were violated by Lois Lerner and perhaps others around her. And I would hope that's the reason your investigation is ongoing. And I look forward to those privilege logs. Thank you, Mr. Chairman. I yield back.
Gentleman from Nevada is recognized, or we're going to come back. We're going to recess. But if you want to go now, we got 3 minutes and 40 seconds left in the vote.
Mr. Chairman, I actually asked for unanimous consent under Rule 9 that the minority be given equal time based on the fact that the Chairman went over additional 5 minutes.
Yeah, I've been very lenient with the time, and I've let the ranking member go over, and we'll be happy to let you go over if you want, but that may mean we miss votes, but go right ahead.
Thank you. Thank you, Mr. General, for being here today, and I want to start by, again, just reiterating the fact that the Chairman asked at the beginning of this hearing for you to swear under oath that you were telling the truth, the whole truth, and nothing but the truth before this committee. And so throughout the questioning, you have indicated that this investigation is ongoing by the Department of Justice. Is that correct?
That's correct.
Is there any reason for members of this committee or for millions of Americans to believe that that is not the case or to believe otherwise?
There's no reason, no.
After the press report was released in January 2014, has Attorney General Holder explicitly stated to the public that the investigation is ongoing?
I believe he has.
Thank you. I want to bring to the committee's attention the fact, again, that many of us agree that there was absolutely wrongdoing by the IRS on the handling of the tax-exempt status, and the process was unacceptable and that people do need to be held accountable. I believe that the President famously referred to the IRS mishandling of these applications on Super Bowl Sunday as consisting of, quote, bonehead decisions. The President went further and commented that there was, quote, not even a smidgen of corruption. Now, much has been made of the President's statements. Chairman Goodlatte asked during a June 11, 2014 judiciary hearing, quote, how can we trust that a dispassionate investigation is being carried out when the President claimed no corruption occurred? During the same hearing, Chairman Goodlatte asked FBI Director James Comey, quote, can you explain why there's an investigation given that the President said that there was not even a smidgen of corruption? Director Comey responded, I mean no disrespect to the President or anybody else who's expressed a point of view about the matter, but I don't care about anyone's characterization of it. I care, and my troops care, only about the facts. There's an investigation because there was a reasonable basis to believe that crimes may have been committed, and so we're conducting that investigation. So, Deputy Attorney General Cole, do you agree with the assessment that outside characterizations, even by the President, have no bearing on a particular investigation?
That's correct. People don't know what it is we know, and they have, we do our job and try to block out whatever people say on the outside.
Is it accurate to say that the Department does not take direction from the President on how to conduct ongoing investigations?
We do not, and that's a very specific line that is drawn.
The gentleman yield.
Yes.
Just for just a second. Mr. Chairman, I understand we have less than a minute, Mr. Chairman. I don't know whether you were coming back. Were you coming back?
Yes.
Can he resume his question when he comes back? I mean, if you don't mind. I want us to be able to vote. Yeah, yeah. Does that make sense? So I just want to make sure we get answers to the question. We're out of time. We've got to get to vote.
But there's 300 people that haven't voted. So
Yeah, well, I'm not going to be one of them.
all right. It's up, but it's totally up to I was going to let you finish.
We can
all 5
recess,
minutes.
Mr. Chairman.
Yeah,
Recess? All right. I'm going to ask one more question. I won't take your time. I'm going to have one quick question before I go.
So I reserve my time, Mr. Chairman, until we return.
All right. You'll be given your full 2.5, 3 minutes, whatever you had left. Mr. Colby, we are going to recess, but before we do, is the Department of Justice investigating why the IRS waited 2 months to disclose the loss of Lois Lerner's emails?
I don't know if that's specifically what we're investigating. We're looking at the loss of the emails.
I'm asking you specifically, are you going to look at the fact that the head of the agency that targeted conservative groups knew in April and didn't tell us and didn't tell you for 2 months? Are you going to look at that fact?
I think that depends on whether or not the IRS the Inspector General refers that to us. This is an area that we'll probably want to satisfy.
Why should what should the Inspector General have to do with it? If
They're
you think
involved
that's
in
a
this.
problem, I certainly think it's a problem. The American people think it's a problem. I would hope the Justice Department would think it's a problem. So why wouldn't you look into the 2-month lag?
We'd have to determine if there's a potential criminal violation before we would look at that. We don't just investigate for no reason. There has to be some sort of basis or some sort of thought that it might implicate a Federal criminal statute. So we'd have to look at that first.
All right. We'll resume. We're going to take a recess. Obviously, we'll be back in probably